Hi, it's Nate Webb from the Webb Law Firm, emphasizing DUI defense in Washington State. I want to talk a little bit about DUI penalties. A lot of people will always want to ask, of course, what am I facing if I'm convicted? And I have a list here below this video, of course, that outlines the statutorily imposed penalties for first offense cases and beyond. Obviously, first offense cases, they are treated a little bit differently than subsequent offenses. A subsequent offense in Washington State under the statute for DUI penalties 46615055 indicates that there's obviously increased penalties. So instead of a 1 or 2 day jail penalty imposed for a conviction for DUI on a first offense, a second or third offense would have significantly increased penalties. For example, a second offense within 7 years of a what's called prior offense. A prior offense can encompass a DUI conviction, a reckless driving conviction, a negligent driving in the first degree, or reckless endangerment. Little known, another charge, reckless endangerment, is rarely imposed, but it is a prior offense for sentencing purposes. So essentially that means if you are convicted of a DUI and or a negligent driving or reckless driving or reckless endangerment on your first offense, and you have a new violation and are convicted of that within a 7-year period from the date of arrest, then there's going to be increased penalties as they are listed below: 30 or 45 days in jail with mandatory electronic home monitoring. Ignition interlock is going to be required for more than 1 year. And so there's many things that come along with that. So it is essential that your DUI attorney understands how this prior offense system works, because I've seen a lot of times where someone might do a deferred prosecution and then they get a subsequent offense and it's not entered properly or appropriately with the court, and the person might be subjected to basically 2 times the penalty they should have been facing. And so you want to have your DUI attorney be acquainted with the penalties, of course, that come along with that. And most people don't realize as well that if you, for example, had a DUI reduced to negligent driving in the first degree on a first offense, and you subsequently have a new DUI that, hey, you might have also reduced to a reckless driving or negligent driving, that you're going to face a mandatory ignition interlock. That's a new imposition the legislature imposed back in September of this past year, so that at any subsequent offense, even if it is reduced from a DUI, you're going to face some ignition interlock penalties. So your attorney needs to be well informed about that. And if you have any questions about penalties and how that's going to apply to your case, mandatory jail, ignition interlock requirements, license suspensions, then of course feel free to give me a call, visit my website. We have a contact form on there, and I'm happy to answer any questions that you would have with respect to DUI penalties. This is Nate Webb, Webb Law Firm, 425-398-4323, webattorney.com. Post it right here, and you can visit us and ask any questions you might have. Thanks.